Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. The information that I'm about to provide is based on current California law. It's general information and not specific legal advice. Today, I'm going to talk with you a bit more about your heirs. Your heirs are the people that will receive your assets when you die if you did not plan ahead and specify who's to receive those assets at your death. This is the 6th video in an 8-part video series. Picking up where we left off after the last time, if any distributions to the surviving spouse of the decedent, if there is a surviving spouse, and after any distributions of assets attributable to the deceased spouse to the relatives of the deceased spouse, as applicable maybe in some cases, after that's done, the assets of the decedent remaining are distributed as follows. If the decedent had living children or grandchildren, then the living children or grandchildren of the decedent will receive all the decedent's assets if to the extent that there are children and grandchildren. The total amount is divided in equal shares based on the number of living children of the decedent and deceased children of the decedent having living children or grandchildren of their own. Each living child of the decedent receives an equal share. The equal share of any deceased child of the decedent is subdivided and distributed equally to that deceased child's children or grandchildren. All right. If there are no living children or grandchildren of the decedent, but there are one or both living parents of the decedent, then the living parent of the decedent will receive, or all the living parents, depending on how many there are, will receive in equal shares all of the decedent's assets. If there are no living children, grandchildren, or parents of the decedent, but there are one or more living siblings or nieces or nephews of the decedent, then the living siblings, nieces, and nephews of the decedent will receive all of the decedent's assets. The total amount is divided in equal shares in the same way that I discussed a moment ago with the children and the grandchildren of the decedent. If there are no living children, grandchildren, parents, siblings, or nieces or nephews of the decedent, then each of the living grandparents of the decedent will receive an equal share of the decedent's assets. So that could be 1/4 or 1/4, depending on how many grandparents are alive. Back when I was talking about parents a moment ago, it could either be all the assets or half, because at most would only have 2 parents. So back on our track, if there are no living children, grandchildren, parents, siblings, nieces or nephews, or grandparents of the decedent, then the living children or grandchildren of the decedent's grandparents, that is the decedent's uncles and aunts, followed by first cousins, will receive all of the decedent's assets. The total amount is divided in equal shares the same way as the children and grandchildren that I spoke about a minute ago. Taking the next step, if there are no living children, no grandchildren, parents, siblings, nieces or nephews, grandparents, or surviving children or grandchildren of the grandparents of the decedent, then the living children or grandchildren of the predeceased spouse of the decedent will receive all of the decedent's assets. The total amount, again, is divided just as the same as it would be for the children and grandchildren of the decedent that I mentioned a moment ago. 3 more steps to go. I know it's a little complicated, but 3 more steps to go. If there are no living children, no living grandchildren, parents, siblings, nieces or nephews, grandparents, surviving children or grandchildren of the grandparents of the decedent, or children or grandchildren of the predeceased spouse of the decedent, then the assets of the decedent go to the closest living relatives of the decedent, whoever they may be. In this case, if there also are absolutely no living relatives of the decedent, then the living parent of the predeceased spouse will receive the assets, or if there's more than one, they'll split in equal shares all the decedent's assets. And then finally, if none of those people are alive, including no living parents of the predeceased spouse of the decedent, then the children or grandchildren of the parents of the predeceased spouse of the decedent. In other words, the predeceased spouse's siblings, nieces, and nephews will receive all of the decedent's assets. And the total amount's divided just as it would be for the children and grandchildren of the decedent that I mentioned in the beginning. As you can tell by going through this list, distribution of assets at death when you don't plan ahead can be very complicated. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning, transfers of assets at death, or even if you just have a question, please contact us and let us take care of you.